Mr. Vries, you may proceed.
May it please the court, I'm Julie Vries. I'm honored to serve as guardian ad litem for the child in this matter. The primary matter before the court is permanency for a precious toddler. The facts, case law, and statute support the preference of termination over guardianship. The record is clear that the grounds for termination were met, and I'll address the best interest of the child. Primary considerations for best interests are emphasized in the matter of PL. This court held in PL that it's legislative intent, not the court's own best interest test. The first consideration under 232.116 subsection 2 is the safety of the child. Safety is the reason this court is hearing the case today. The child was sexually abused by her father. Due to no fault, potentially, of the mother, she wasn't present at the time, but she did leave the child in the presence of the father, who was known to be intoxicated.
He's serving a life prison sentence with no possibility of parole. He's out of the picture. Is that the end of our concern over safety for this child?
No, Your Honor. Regarding the father, first of all, the time for his criminal appeal has not run, so that's a potential concern. Regarding the mother, she was provided services for 15 months from the time of the child's removal until termination. Despite all the services offered to her, even meeting her special needs of having a 4th grade reading level, having 4th grade comprehension level, having an IQ of 70, she wasn't able to make the decisions that would keep the child safe. Concerns, feeding concerns, diapering concerns, she just wasn't able to make the progress necessary.
Wasn't it struck me that the DHS principal concern about mom was her lack of awareness about the danger posed by dad. And getting back to Justice Waterman's point, with dad now out of the picture, likely for a long time, perhaps, is that really something that should tip the scale here?
The safety of the child will always be at issue because the mother didn't understand that intoxicated persons are not able to care for infants. There were other concerns raised later regarding safety. Even in the home where she lived with her parents, the maternal grandparents, there were concerns of domestic violence. Again, the mother wasn't able to just take care of the basic needs of the child, let alone recognize dangers.
The Court of Appeals apparently saw the record differently. The majority of the Court of Appeals, as I read their opinion, seemed to conclude that that the child was flourishing in its current environment with the grandparents, and that there had been a home study, and that came back without problems. So apparently they did not on de novo review accept the notion that there was such a risk of domestic violence in that home that should justify termination, correct?
That is correct. The child was doing fairly well in the grandparents' home. However, the concerns didn't actually arise until about 3 months before termination. So immediately after a permanency review hearing held in March of this year, that's when the first concerns of domestic violence arose. The mother herself reported to the department that she was struck by the grandfather in the presence of the child. The CASA worker, who's highly experienced, 18 years in her position, she actually was asking for removal at that time. Because we wanted to make sure reasonable efforts were met, the CASA worker actually asked for someone to go and check in the home 3 times a week, plus the FSRP services already in place, plus the department services of checking on the home. So really, the robust supervision is what kept that child safe. If that was to disappear, if the guardianship was still to be the only supervision by the court, it's simply not sufficient. I, as guardian ad litem, the CASA worker, the department, the FSRP worker, all of us have concerns that that could be a long-term placement because there won't be enough supervision by all the parties.
Could you address the principle in our law that we favor placement with relatives, and here we have the grandparents who have been raising this child?
Right. Under 232.116, subsection 3, the exceptions determination, one of the exceptions is placement with a relative would be a good ground for not terminating. However, in this case, that's simply not appropriate because although there was mention of a home study, at the time of termination, there were also 2 other home studies. The department had done home studies on 2 maternal uncles and their wives. Those might be better placements. It's really the department's position at termination to make sure that the best home is selected, and that's part of 232.1162, the best interest argument. We're looking for the best placement. We're not looking at where the child may have been okay, maybe where the child has been, but what is the best long-term placement? That's a responsibility of the court.
Did you advocate as guardian ad litem that those other possibilities for placement were superior and should be adopted? Or did you just argue for termination?
I argued for termination and that the department is the best entity to really decide who the best placement long-term would be. So the department is the one that does the home studies. Yes, there was an initial home study, which is not equivalent to a pre-adoptive home study on the grandparents. The grandparents didn't even express their interest in pursuing foster and adoptive licensing until about 3 months before termination, although the department offered that service long before that. So yes, I asked for a consideration of all potential relative placements. The grandparents were never ruled out. They just weren't considered under the same kind of guidelines that these other home studies were considered.
Why didn't the grandparents testify?
That's a good question, Your Honor. Honestly, that would have helped their case under .116 subsection 2. One of the considerations the court can hear is a written statement or testimony by a person who's giving care to the child. That wasn't provided to the court, so the court didn't have much information beyond a statement by the department that a home study was initially completed before the child was placed.
Was there even really, I mean, kind of reviewing the record, was there even really an argument for guardianship specifically for guardianship raised in the juvenile court, or is that just something that the Court of Appeals kind of came up with? That was an impression I got, and I'm just wondering about that.
The mother's counsel, I do believe at trial, mentioned that guardianship was an alternative. However, the grandparents didn't ask for guardianship. The court actually found that guardianship would be woefully inadequate for a permanent placement for the child, which is what all of the case law has held up to this point. The case of LMF, all those cases that cite LMF, this is really a rare exception, especially considering the child just turned 2 last month. She was 18 months at the time of termination.
Let me ask you about the legal standard. All right, so you have the best interest of the child. That's one of the statutory requirements for termination. But then it seems the way the statute's structured, even if that standard's met, the court need not terminate if a relative has legal custody of the child. So what is the legal standard for that exception? When do you apply that exception? Is that still also fall under the best interest? I mean, the statute itself doesn't give us guidance.
Right, but case law does show that those exceptions are permissive, they're not mandatory. And so the trial court's the one with the best discretion to determine based on the facts if an exception would meet the best interest of the child. In this case, the trial court did not find that permissive factor of placement with relative was not enough to meet the exception. With that, if I could just defer to the state for the remainder of this argument. Thank you.
Thank you as well. Ms. Dixit.
May it please the court, my name is Anna Dixit. I represent the state. Although guardianship is appropriate in some circumstances, this is not that case. Guardianship is not a legally preferred alternative to termination, and we've seen that in numerous Court of Appeals cases. In recent Court of Appeals history, there have only been 2 circumstances in which guardianship was favored over termination. This is one of them, and the other one is In Re BT. The facts in Re BT are so dramatically different than the ones that we have at hand today, which provides no guidance to the district court in which case guardianship when it would be appropriate. Now, if we look at In Re BT, we have a situation in which the child is older, able to express his preference, already has a history of living in the grandmother's house, already has a close relationship with the mother, and the mother in that case has shown time periods in which she is able to safely and adequately provide for the needs of the child. That simply is not the case here. More importantly, if this court were to determine that guardianship is appropriate, then guardianship with the maternal grandparents should not be the result, and it should be left to the department to make the ultimate determination on who is the appropriate guardian.
I mean, let me ask you a question. This strikes me as somewhat of an unusual guardianship based on at least my experience when I was on the Court of Appeals. Usually when there's a guardianship, the parent is not really the one taking care of the child, the guardian is. Here it seems like the theory that the Court of Appeals operated under was that the parent was admittedly not fully capable of caring for the child, needed help, and the idea was the parent would live with the grandparents and the grandparents would provide help, and that was the theory behind the guardianship. Is that a model that is common? Is that something that DHS will bless under appropriate circumstances?
Not at all, Your Honor. Because DHS's position and the state's position is that guardianship is not actually a permanent option, it means that in the situations that you've described that you're familiar with, there's a chance that somewhere down the road, that guardianship can be terminated and that parent can retake custody of the child. In this case...
Well, but that's what we had in this case, because I think the record reflects that once the child becomes more self-sufficient, then the mother, even with her limited parenting skills, could in fact reassert parental responsibility for this child. Isn't that what the record shows in this case as well? So maybe the guardianship is a stopgap way of doing that.
Respectfully, Your Honor, I would disagree with that interpretation of the record, because even in the psychological assessment, the evaluator concluded that it was not his recommendation that the child be given back to the custody of the mother, and that if it was to be determined that the mother would retake custody of the child on her own, that she would still require supervision up to 3 times a week. Someone would have to come in and check on her up to 3 times a week. The CASA worker, the guardian ad litem, the district court, the department all concluded that there was no future time in which the mother would be able to parent this child without the hovering supervision that the district court ultimately determined the mother would require. In fact, even the Court of Appeals stated that it wasn't likely that this mother would ever be able to parent this child alone, which is why guardianship is not the appropriate option. In a guardianship, a mother could come out every 6 months and ask for the termination of a guardianship. That's like the sword of Damocles hanging over this child's head, with this child and her guardians wondering when this mother will be coming in to try and terminate this guardianship. Even if the court is the ultimate decision maker here, even if the court decides, no, the mother is never going to be ready, and every 6 months decides you're not going to terminate guardianship, that's a stressor on that child's life. That's a stressor on those guardians' lives. And that's not just a matter of a year or two, as would be the case with an older child. It's a matter of 16 years in this child's life. That is not stable. That is not security, and that's not permanency. That's why guardianship is the inappropriate choice in this case. Furthermore, although the mother has an intellectual disability, she was granted that additional time to try and meet that reunification. And unfortunately, even with an intellectual disability, although that can't be the determinative factor, it can absolutely be a factor that the court considers. For those reasons, we ask that you reverse the decision of the Court of Appeals. Thank you.
Ms. Dixit, thank you as well. Mr. Boswell.
May it please the court. My name is Robert Boswell, and I represent the mother in this case. We are here today to ask you to affirm the Court of Appeals decision in the sense that a guardianship is appropriate in this particular case under the facts of this case. This case is peculiar. I'm not asking the court, I'm not here today to say that the court needs to overrule long lines of precedent, but there are times when the law is correct under the facts of a particular case, and that's what we're stressing with regard to this issue. In this particular case, this mother had this child removed very early because she made a poor decision. There is no doubt about that. She made a poor decision. One of the things that struck me, I was not the attorney of record during the China proceedings, which is somewhat like a long trial that's extended over a period of time. However, what struck me when I started looking at the records in this case, it was clear that the Department of Human Services was very concerned about this decision the mother had made with regard to leaving this child. And so I started asking questions. I asked the witnesses, what did you do about that concern? If you were that concerned about this, what did you do about it? And I couldn't get an answer from anyone. Even though they were concerned about this decision, they never really spent any time whatsoever discussing with this mother the ramifications of whether this person had been drinking or not. What I also noted from this documents that I reviewed, I couldn't tell that anyone had ever asked this mother, who is a non-drinker according to the record, what do you mean when you say someone is intoxicated? And explore that issue with her.
Let me kind of zero in on what my concern is. And it's this, and Ms. Vries, I think, alluded to it, and there is, it seems, a significant amount of evidence in the record that there's a bad dynamic between the maternal grandfather and the mother, and that is going to affect the child, and that's a problem. And unfortunately, there really was the only evidence in the record is what came from the CASA and the DHS worker and so forth, because you, although I think you did a great job reading the transcript, you didn't call anybody from the family themselves to testify. So on that basis, how do we overturn what the juvenile court did?
Well, this issue that came up during the trial, that's when it came up. Well, I was not aware that there had been this issue. I'm not even certain from the record when this incident occurred, whether it occurred very early or whether it occurred at all. There was some discussion. There was another discussion about some incident occurred outside the courtroom. It came from the CASA worker, and it became clear to me that the CASA worker did see any of the incidents that she was testifying about.
I mean, the DHS worker, I think, testified under oath that the maternal grandfather hit her, and this was after the case had already started. So that would have been recently, I think, within the last few months.
I think what the worker testified to was that the mother had reported there had been an incident and she had been slapped because there was a disagreement. There was a lot of stress in this family. One of the things that kind of struck me is that, and I don't think it was given due credit to this family, is that this family was basically torn apart. And they were going through a grieving process. They were angry at the father. They were angry, I think, with themselves, because you feel some sort of responsibility, and I think they were left to have that responsibility. This family went through a period of deniability.
All may be true, but none of them came in and testified, right?
But the family had been supportive of this mother throughout. I think that the assumption was that when family has been taking care of this child throughout the entire China case, this child was removed, placed with these grandparents. Throughout the rest of the China case, the mother, a few months after it started, moved in with her parents because she couldn't afford to maintain her own home. And so these grandparents and this mother all lived together throughout the entire case. And what they were trying to do was make sure that the mother was the primary caregiver, that she did. And I think the record will show that when the workers would come in, it was mother who was doing the bathing. It was mother who was changing the diaper. And so
The idea is that in the future, the workers won't have to come in, that there will be a stability. And the theory I think the Court of Appeals operated on was that the grandparents would provide whatever is kind of any deficiencies in the mother's caretaking, they would make up for that. But how do we have the basis to conclude that on this record? That's my problem.
Well, they had been taking care of that child throughout. And I think their assumption, and everyone's assumption, is that they remain there. And that was the plan.
Counsel, could you address the other perhaps shortcomings of this arrangement, that the grandfather worked odd hours, that there was discord, that they had a special needs son they were also taking care of?
The home that this child lived in, for all intents and purposes, appeared to be appropriate. I understand there were, when, it seems like when there's testimony, it comes from either the CASA or the DHS worker, and they're supporting a termination of parental rights, they tend to focus on a lot of what they call concerns. And so you raise all these concerns. But I couldn't tell from the record when I was looking back through the China case that any of these concerns rose to a level where they tried to do something about it. They have these meetings that are called family team meetings and staffings and things like that. From what I could tell, there was one family team meeting some 6 or 7 months prior to the petition for termination of parental rights that the mother attended, and that was the only one they had her attend. This family and this mother, up until she arrived in court in January, and a few days before the hearings when the report was filed saying that there was going to be a termination of parental rights. Up until that point, this family believed this child was going to be able to stay with them and stay with the mother, and that they didn't know there was going to be a termination of parental rights. They never saw the urgency, and it seemed unfair to me to expect a parent. I think a parent, if they're getting close and the department and the guardian ad litem says, you know what, this looks like it's going to move to termination, then I think it's incumbent upon them. There ought to be a meeting. They should have to come in, explain to this parent, this is where you failed. This is what you need to do, and this is how I need you to demonstrate it so that you can avoid a termination. Didn't happen in this case.
Let me tell you what my concern is, kind of a two-pronged concern about this particular case is I don't see how, and this may be my personal bias, how does this establishment of this guardianship lead to the permanency that this child requires? And then kind of the second prong of that same argument is, why is this in the best interest of the child? I see a guardianship as being certainly a less, it's not a termination, so that's a better alternative for your client. But by the same token, how does this lead to permanency? When you have a guardianship established, you file annual reports, it's still going to require continuing services of DHS. I just don't see this as being, the permanency that we require our juvenile judges to instill in this particular child. And so maybe you can answer just what those are my two concerns here.
Well, and I guess it would be my argument that this guardianship, this proposal that was reached through the Court of Appeals, was really almost like a compromise between those two sets of facts. And I think it's because the psychologist, when they interviewed the mother and made some recommendations, so I think what they were looking for is that it would seem to me that it's always in the best interest of a child to stay with their biological parent unless, except under extreme circumstances. This father's rights should be terminated. There's no doubt about that. But with regard to this mother, she had an intellectual disability. She made a bad choice, so that you try to fix that part of it. This mother she's not on some program where she's employed. She was employed throughout. She has a driver's license. She learns differently than other people, but she's more than capable. Every report said she was taking care of the child. So I think this was a compromise so that at some point, if the mother was able, she could petition the court. And this would keep the child in the same home that the child had always been. One of the workers, it was one of the FSRP workers, testified that there was some programming that would have allowed some services to be able to come in and out of the mother's home on a daily basis. They had not been available prior, but had become available. So I think this was a compromise.
But you have the juvenile judge who specifically does analyze that. And again, I give a lot of deference to the juvenile judges in these circumstances because it's the one child, one family, one judge type of scenario who has lived with this for the entire course of this juvenile proceeding. And he does, in fact, specifically make reference in his findings of fact, that he did consider the guardianship, doesn't see it as a viable permanency alternative, and doesn't see it as being in the best interest of the child. And then again, we have the Court of Appeals who takes a different approach to this. and I know we get to look at it de novo as well, so we get to look at it anew too, but I just have trouble not supporting what the juvenile judge who's lived with this case for 18 months has made that determination. So, it's maybe my personal bias on that, but you're gonna have to, try to convince me otherwise.
Well, I think, first of all, you'd have to be a fairly bold juvenile court judge to start establishing these guardianships, because almost all the case law would go against you. So if you're concerned about, is this the case, you might second guess that and say, you know what, permanency, and if I do permanency, there's a termination, and the grandparents can just adopt. Well, they may be able to adopt, but in this particular case, at the very end, you have some other family members who, to my knowledge, had never been involved in this case, are all of a sudden doing home studies and showing up, and it caused a lot of turmoil. And I think there's some of that in the record.
Is that okay
And
too?
so I think the court, the safest way to do this is to go ahead and terminate and let the family fight it out, I guess, in adoption court. I think it's dangerous business to start choosing what we consider to be the best family. To me, the best family is the biological family, the family where the child's been living throughout their entire life, and unless there's some real dangerous situation that's going to cause some harm to this child, that's where they need to stay. The department, I spent 11 years as a county attorney. I never remember having a case that we ever closed where the department couldn't come into court and list for me numerous concerns that they have. They always have concerns because they know if something goes wrong, they're going to end up in the paper. And so they always have concerns even when they close cases. So I think this really struck a balance that I think is appropriate in this case. I don't think it needs to be the law of the land in every single case. This is this particular case. This was going to give this mother the opportunity to get the support she needed from her family. The child was going to get to stay right where they've been living their entire life. And I think what the Court of Appeals did was strike a balance that kind of met all those things, provide some protection to the child. And I think it is appropriate that if at some point the mother is able to petition and regain custody when this child's older, what would be wrong with that? If it's a safe placement, what would be wrong with reuniting this mother and child?
On that point, what progress does the record show she was making that would enable the court to predict that, boy, she's, that's next year or 2 years from now? Because it seems indefinite that maybe this is the status quo and we're looking at 16 years of oversight and visits.
A couple of things. One of the things that concerned me when I was looking at these reports, I was trying to figure out what had they been doing over time and what were the goals mom was supposed to reach. That's why I was saying earlier, those goals need to be clear cut. And so when I'm looking through this record, I'm not finding where they're faulting mom for anything. They had some concerns over some diapering, some concerns over feeding. This child was seen by a doctor regularly, mandatory reporters regularly, and no one saw anything to be so dangerous. And so I never could find out what it was. What did they want her to do? How was she going to demonstrate it? It was if, and from my perspective, I'm looking at this, she made this mistake at the very beginning, and there's no coming back for it. Don't even need to really do anything.
It did seem that everybody who testified and the psychologists as well, they all agreed the mother is not capable of raising this child without outside assistance. And I guess the theory of the Court of Appeals was that the grandparents could provide this outside assistance. And the concern that was reflected at the hearing was there's emotional turmoil, there's even this issue of physical abuse between the grandfather and mother. That's not a good solution.
And I think,
Am I missing the record, or?
well, and I see I've reached a stop, but from my perspective, a lot of this turmoil was created when these family members who hadn't been involved come into the picture, and now it's like there's going to be a grab. And so, but throughout this case, at no time did everybody say, that this is such a dangerous situation, we need to remove this child. These issues came up at trial. That's when this issue about this slap and all that this wasn't part of the record from before. And what I was asking some of these workers, if this mother learns differently, and you can't just say, well, here's a piece of paper, take it home and read it, and we'll have a quiz later, which seems to be what they did. So I asked them, when did you change that? And the answer that I got was, oh, in February or March, after the termination petition had been filed. That should have happened from the get-go. From the moment they got that psychologist report back in June of 16, they should have changed. And when I asked them, when did you start doing this one-on-one? When did you really change? Oh, in February or March, after the termination petition had been filed. From my perspective, that's too little too late on the department side. So, thank you.
Mr. Boswell, thank you as well. Ms. Dixit?
May it please the court? Opposing counsel stood up here and said that it was a concern for the juvenile court to perhaps not try to overturn the history of not implementing guardianships, and that was the reasoning behind their choice not to implement this guardianship. That simply was not the case. In the decision by the district court, by the juvenile court, the judge didn't say that because of this long history that we have of not implementing guardianships, that's why I'm not entering a guardianship. He said it simply just wasn't feasible. It wasn't workable with the case at hand. He did the analysis of what was appropriate for this child, and termination was in this child's best interest. There was also a discussion about the grieving process, about the mother's inability to process what was happening, and the one mistake that she made in the case. Of course, we're not going to stand up here and fault the mother and say that she should have known that when she left her infant child with an intoxicated man, that this horrendous crime was going to occur. Absolutely not. But she should have known that when she left her infant child with an intoxicated man, something bad could happen. And something bad did. And the fact is that even prior to this incident, when the child was first born in the hospital, it was failure to thrive. She had failure to thrive because the mother failed to recognize signals of when her child was hungry, when her child needed to be changed. This infant suffered months of diaper rash because the mother couldn't understand how to properly treat that rash, how to adequately provide for the physical, emotional, mental, and safety needs of this child, the very basic tenets of our best interest analysis.
Does the state provide services just to enable the parent to parent, or are services provided because it's always going to be necessary for that parent to have assistance in raising the child? What do you do with a parent that has an intellectual disability that, with proper assistance, seems to do okay, but if you take it away, then that fear is overwhelming? What do we do?
So for the department, of course, they have a requirement to provide reasonable efforts. And in this case, they provided reasonable efforts that were adequate to meet the special circumstances surrounding an intellectual disability. Now, Wardle and INRI, RMS have told us an intellectual disability alone can't be the grounds for termination. But when it affects the child's well-being, how long can the department be expected to provide services? How long can anyone be expected to constantly provide this hovering supervision that will allow this parent to actually parent?
Does the record show that with continuing services, she will improve and be able to, in some time in the foreseeable future, care for the child?
Your Honor, the record is actually unclear on that, because certainly the mother improved with the immediate necessities of this baby, right? She learned how to change a diaper. She learned how to treat a diaper rash. But what happens if down the road the child decides she wants to go cross the street and the mother doesn't understand how to properly instruct her on the safety behind that? Or if the child decides that she wants to go to the park by herself and the mother doesn't understand the safety concerns surrounding that? At what point do we constantly try and teach the parent how to parent? If it takes her 2 years versus 2 months to learn how to change a diaper, then what does the long term look like for this child?
Well, that's my question. When are we then not terminating because of an intellectual disability. In raising a child, a parent is constantly challenged, and challenged again the next week and the next month and the next year with all sorts of things that await. And so when is it we're not actually terminating because of the disability?
Absolutely, Your Honor. When the parent is able to show that they understand the basic safety concerns with some tutelage.
Okay, in the moment, I mean, this mother understands now how to take care of a diaper rash and change diapers appropriately and everything. So at that particular moment in time, the mother's doing okay. A year from now, there's going to be a new challenge. New services will be necessary to instruct on what to do. And then next year, it's going to be a continuing thing. But it's all related to her disability, isn't it?
I do see that my time has expired, if I may respond. Your Honor, yes, the intellectual disability affects the long-term parenting abilities of this individual. But when it so seriously affects the child's well-being, when it requires not only constant hovering supervision, but involvement by multiple people, not just a guardian, but the department, but the CASA workers, but the GAL, at that point, we have to be able to draw the line and say that the intellectual disability so severely affects this parent's ability to parent this child that termination is in the child's best interest. And that's what's happened here. There are circumstances under which an individual with an intellectual disability could properly respond to services and be provided those in the long term, and there aren't going to be major concerns about a child's safety, but this is not that case. Thank you.
Ms. Dixit, thank you as well, and Mr. Boswell, thank you again. The case of AS is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.